The lore of legality, conning the court. In the mythology of multi-level marketing, no aspect is more consequential than the contention that MLM was tested in the federal court and found to be perfectly legal. In 1979, Amway, the largest and oldest existing MLM, was exonerated by a judge of a charge brought by the FTC that it was an illegal, endless chain. In the MLM legend, this court ruling is enshrined like scripture and referenced by MLM promoters as the ultimate judicial authority. Without a hint of its extreme irony, the first line of legal defense among all MLMs against questions of deception, cultism, or a bogus income opportunity is, quote, "We operate like Amway." The reality of this court ruling is radically different from the tale. The ruling of 1979 was not made in a federal district court, an appeals court, or by the Supreme Court, or any court presided over by a presidentially appointed federal judge, as might be supposed from the great status accorded the ruling. It was made by an administrative law judge, ALJ, James P. Timoney. ALJs are paid by the agencies for which they hear cases. Timoney was brought in a year after the FTC's pyramid scheme case against Amway was already underway. Judge Timoney had never before adjudicated a pyramid scheme case. Prior to becoming an ALJ, Timoney had worked in the FTC's Restraint of Trade Division and in the General Counsel's office. After the Amway case, Timoney heard cases from 17 different government agencies. He retired in 2003 and has never made a public statement or been publicly interviewed about his famous decision. There has never been an academic review of the ruling or an assessment of the validity of his conclusions in which real-world sales experience, actual loss rates, and retail sales data are measured. Officially, ALJs are part of the executive branch, not the judiciary. They are appointed after passing a test and an interview in front of a panel. There are twice as many ALJs as there are federal court judges, and they hear twice as many cases. The majority of cases are individual disputes with the Social Security Office. The cases are called, quote, trial-like, but there is no option for a jury. Enforcement of their rulings requires formal acceptance by the government agency bringing the case. The agency has the option to appeal to an actual judicial court, and it could reject the decision. If the agency accepts the decision, the ALJ ruling, unlike a federal court ruling, is not binding on future actions of the agency. It is not necessarily applicable to any other case against other companies. ALJ decisions do not require the agency to use the rulings for general guidance to other similar companies regarding boundaries of legality. Today, in consumer protection cases, the FTC has essentially abandoned using ALJs in favor of litigation in federal court. Despite the low status and non-binding nature of the ALJ decision, the FTC accepted the pyramid scheme exoneration in the Amway case without appeal. Ever since, the FTC has referenced the ruling as the model on which the entire multi-level marketing industry is defined, making MLM legal, fair, and legitimate, not inherently deceptive and harmful, unless an MLM company might be determined to operate otherwise. The formal acceptance was written by Commissioner Robert Pitofsky, one of that special class of attorneys and academics that moves back and forth between the regulatory agencies and law schools and politically connected law firms representing corporate clients particularly affected by regulation. Pitofsky led the FTC's Consumer Protection Bureau between 70 and 73, when President Richard Nixon named Miles Kirkpatrick FTC chairman. Pitofsky was made an FTC commissioner 1978 to 81 under Jimmy Carter, and later commission chair 1995 to 2001 under Bill Clinton, during which term he oversaw the FTC's approval of the merger of America Online and Time Warner. Pitofsky also served as counsel to the well-connected D.C. office of the law firm Arnold and Porter and taught antitrust law at Georgetown Law School. The antitrust backgrounds of both Timoney and Commissioner Pitofsky are reflected in the ALJ's ruling and Pitofsky's written acceptance for the commission at the cost of consumer protection elements of the case. Imaginary retail, fabricated rules. Judge Timoney's opinion that Amway was not an endless chain in violation of FTC law against unfair and deceptive trade practices was based on the unfounded and implausible claim made by Amway that its entire business was, quote, retail-based. The judge chose not to verify the retail sales claim with data or field research inquiry, relying instead on the accused company's word. Accepting retail selling as the company's primary activity, much of the rest of the case then dealt with competition and pricing. In reality, and as Amway later disclosed, virtually no profitable retailing occurred, making pricing and competition with true retailers like Procter & Gamble irrelevant. The most memorable and consequential part of the ruling was based on Amway's claim that it had rules that ensured that revenue would always be based on retail selling, and that all salespeople were chiefly gaining their income and earning profits from retail selling, directly with their own retail sales or indirectly from the retail sales of the genealogy of their recruits, called a downline. The rules were invented by Amway. They were not referenced by FTC attorneys in the initial complaint. They entered the case as evidence and proof that the company was, quote, retail-based. These rules, according to Amway, required every salesperson who received a bonus to have at least 10 retail customers monthly and to have resold 70% of all products ordered monthly to retail customers or to other salespeople. If the rules had been enforced, those who did not sell the goods they purchased received no bonuses, which the FTC found were the great majority. The payments to the recruiters were made by Amway, and only to those that successfully recruited consumers to join the chain or purchased a quota of goods. No data were produced, however, to show how many customers, other than the people inside the closed recruiting chain, ever bought Amway goods on the open market. No data or evidence were presented showing average pricing or profit to the salespeople or the total volume of open market retail sales. Using raw data of company revenue and total number of recruits cited in the case of $200 million in revenue with 360,000 recruits, the monthly purchase per person among people on the recruiting chain was about $45 a month, impossibly small for retailing. Even though Amway paid its recruiters before retail sales were made, if any occurred at all, Judge Timoney accepted Amway's word that the rules guaranteed that people on the recruiting chain were never induced to buy goods as the cost to join the recruiting chain or maintain eligibility for recruiting-based rewards. The claim that after the recruits made the purchases, retail sales occurred was accepted without verification. After the judge's ruling, the claim to include the Amway rules in their own policies became the primary defense of every MLM against pyramid scheme charges. Neither the judge nor the FTC inquired whether or not the rules actually prevented the deception and harm inherent to a pyramid recruiting plan. The deception would include being falsely induced to sign the contract and make purchases in the expectation of gaining income from retailing or recruiting. Neither the judge nor the FTC looked at the business directly as it operated on the street. To this day, the validity of the rules to ensure retail selling and to prevent deception and harm has never been verified, and the FTC has made no inquiry. Yet in the acceptance of the ruling, Commissioner Petofsky wrote and quoted from the ruling. Amway's 10-customer rule makes retail selling an essential part of being a distributor. Specifically, the Amway plan is not a plan where participants purchase the right to earn profits by recruiting other participants who themselves are interested in recruitment fees rather than the sale of products. Apparently, neither the judge nor Commissioner Petofsky considered the possibility that the rules, which Amway itself invented and made part of its defense, might be fake, ineffective, or just irrelevant to the deceptiveness and harmfulness inherent to any endless chain income proposition. They did not ask, for example, what sales company would ever need to require its salespeople to make sales if the plan had not falsely induced them to buy the goods, or if they believed they could gain income in some other way. They seemingly saw no cause to suspect that inducing recruits to purchase goods with quotas might be tied to receiving recruiting rewards. They appeared to believe that thousands of people were signing up to reap minimal rewards from unverified retailing of Amway commodities rather than from the unlimited wealth that Amway promised from recruiting. In the same vein, they apparently saw no contradiction in salespeople personally retailing and then being rewarded for signing up their own retail competitors. The judge and the FTC commissioner even cited data showing a potential of perhaps $3 a week in average retail profit per person before selling costs and taxes are deducted if all the products were actually retailed. The court also cited evidence that much of the products purchased by the recruits was never sold but was personally consumed. Still, the judge saw nothing amiss in this picture.